So good evening, everyone. Thank you to you all and to the MBA Northern Suburbs Division for the opportunity to present to you all this evening. My name is Anish Wilson and I'm an associate lawyer at Kreisson. We at Kreisson are a progressive and solutions-driven law firm, and we provide legal services in the building, construction and engineering industries. Please feel free to follow us on Facebook, Instagram and LinkedIn for regular updates that we post in these industries. I'm just going to do the classic lawyer thing here with a small disclaimer, and that is that nothing in this presentation should be taken as legal advice. You should also always seek legal advice that considers and applies to your own particular circumstances. So what will we talk about today? Three matters in general. The first one is the High Court case of Mann versus Patterson Constructions and the concept of quantum Meruit. Secondly, the Western Australian case of CMA Assets and John Holland, which deals with clauses that require parties to do things within strict timeframes if they want to claim things such as extensions of time, delayed costs, and variations. Whilst this isn't a recent case, it is a hot topic in the industry at the moment, and a very hot topic in a large adjudication that Kreisson is currently working on. And we'll round it out with a short discussion on dispute resolution clauses in your construction contracts, and followed by some time for questions if time permits. So the background of Mann and Patterson Constructions. So this is a judgment of the High Court made in October 2019, and it started on 4th of March 2014, when the Manns entered into a contract with Patterson Constructions for the construction of 2 townhouses. Payments were to be made at the completion of stages. So this is important as the completion of stages in this contract is what gave Patterson their contractual right to payment. And I'll ask you all to remember that because it's an important point. During construction, the owners requested 42 variations, but none of those variations were documented by notices in writing by the builder. So we had the 42 variations, none were in writing. And that was a requirement under Section 38 of the Victorian Domestic Building Contracts Act. On 18 or 19 March, the owners made what they called a final payment, but it did not include payment for variations. Short time afterwards, at the handover of Unit 1, the builder told the owners, well, you still owe us $48,000 for the variations. The owners said, well, we'll see about that. On 16 April 2015, the owner's lawyers wrote to the builder's lawyers. They alleged that the builder had said that he would not complete the works for Unit 2 until they had been paid the variations. The owners alleged that that conduct had amounted to a repudiation or an intention to not be bound by the terms of the contract, and so the owners terminated the contract. And then on 28 April 2015, the builder's lawyers responded saying that the owner's conduct itself was a repudiation and that the builder terminated the contract. So this was a very drawn out proceeding, and the builder commenced proceedings on 25 June 2015 in the Victorian Civil and Administrative Tribunal, or VCAT. On 12 December 2016, VCAT awarded approximately $660,000 to the builder for variations in the work that it had completed. The owners appealed that to the Supreme Court, which dismissed the appeal on 19 March 2018. The owners appealed again to the Court of Appeal, which dismissed the appeal again on 12 September 2018. And then the owners appealed to the High Court. And on 9 October 2019, the High Court granted the appeal, but transferred the case back to VCAT to determine the amount of damages payable to the builder according to the principles which it had now clarified. So you can see there was a fair bit of pain in the form of time and costs there for the parties over an extended period of time, and it's not even over yet. So the court looked at this principle of quantum Meruit. So what is it? It's a Latin phrase which means awarding someone the reasonable value of work performed, or as much as he or she deserved. It's a restitutionary claim, which means it restores a person the gains that someone else has obtained from their work. And it's based on common law, which means it's based on a collection of decided cases rather than legislation. Now, before the Mann and Patterson case, if a contract was terminated, a builder could elect to claim the reasonable value for their work. That assessment of reasonable value often exceeded what the contract price was, but this case changes that. So there were three judgments. The first three judges said quantum meruit, or claiming reasonable value, was not available and the contract had to be followed strictly. Another three judges said quantum meruit was available, but only if the contract did not give the parties the right to payment for the work they performed, and limited the quantum meruit or reasonable value to the contract price. And the final judge agreed with the second group, making their decision the majority decision. So how does this work? As stated earlier, before this case, if a contract was terminated, a builder would elect to claim reasonable value, and that reasonable value sometimes would exceed the contract price. It was as if the contract had never existed in the first place. But the scenario now can be seen in this diagram. So say you carry on your work, which is demonstrated by the hammers there, and you reach your reference dates or your completion of stages, which I've shown here there in green with the $ right to payment. So you do your work, you get your right to claim, you make your claim, you get paid. The same thing happens a second time. But say you then continue work, and before your next right to payment, the contract's terminated. So for any work that you carried out that relates to a reference date or completion of a stage, that is work you have a right to payment for, a contractor must claim according to the contract. But for any work past that stage, you claim the quantum meruit amount, and that's the reasonable value, mostly assessed by a QS report. However, if that reasonable value is higher than the contract price for that stage, the contractor is then limited to the contract price for that stage. So the court is basically saying you can't claim for more than what is in your contract. That is because the court's view is that the contract allocates the risk between the parties, and that should not be changed. And builders cannot claim a windfall or inflict a punishment when owners wrongly repudiate a contract. So in summary, the contract reigns supreme. On a side note, the court also held that since the builder that the builder could not claim reasonable value for its variations because it had not complied with the strict notice provisions in relation to variations in the Victorian Domestic Building Contract Act. So the key takeaways from Mann and Patterson are: always seek advice before terminating a contract and when another party is attempting to terminate. Timing is really important, and it will have major implications on the course of the dispute. Price the contract adequately and don't underprice. Outline the assumptions adopted and the exclusions clearly, because the contract will be scrutinized closely to assess damages if it's terminated. Comply with the contract and keep formal records in writing. These may be required to prove your entitlement to payment. Get advice on the wording and the form of your notices under the contract. Strict compliance is often required. And the courts have emphasized the need for honest trade and commerce and eliminated the scenarios where contractors are awarded the reasonable value of their work where they had perhaps underpriced their contract. So now I'll move on to the case of CMA Assets and John Holland. So this starts in 2005 when BHP Billiton engaged John Holland to upgrade and extend a wharf at Finucane Island in WA. John Holland subcontracted some of the works to CMA, particularly the demolition of mooring dolphin structures. So these dolphin structures are man-made structures that extend above the water. They're not connected to the shoreline, and they're used to moor boats and other vessels. In September 2006, CMA was delayed with its work because the dolphins were more reinforced than they had first thought. There were also larger fragments than expected from the blasting of the dolphins and difficulties removing those fragments from the seabed. So it was obvious, and then in October 2006, CMA is further delayed by John Holland. And that's because John Holland had to move a ship loader for CMA to continue its work, and it was delayed in doing that. So it was obvious that the parties were aware of the delays, and John Holland partly caused the delays. However, CMA waited until 21 February 2007, so about 5 months after the first delay, to submit a formal extension of time claim. By 2007 in October, CMA and John Holland were in dispute about a wide range of issues, but particularly regarding extension of time, delay costs, and variations. So this case concerned the strict application of time bar provisions. A time bar provision is a contract term that sets a period of time within which a party must do something in order to make a claim or be entitled to something under the contract. It stops a party from being able to claim something if the time period has passed and a party has not done what it should have. In the contract, in this case, clauses 10.11 and 10.12 required CMA to do the following in relation to extension of time claims. Give immediate notice once it became aware of a likelihood of a delay. Within 7 days of the delay event, give notice of intention to claim an extension of time. Within 14 days of the delay event, give a detailed claim for extension of time. And then every 5 days, give further detailed written claims for extensions of time. So it can be seen that these requirements were quite onerous, considering the large scale of the works that CMA were performing and the issues that they were encountering on the scene, on the ground. However, in this case, CMA gave their first notice of extension of time about 5 months after the first delay event. So the court said that even though John Holland partly caused CMA's delay, and even though John Holland knew about all the delays, CMA's extension of time claim should be denied because it did not strictly comply with the contract in the time frame stipulated. The full quote from the court at paragraph 375 is there on the slide, but in summary, it said that even the clauses were harsh, they were clear words and they had to be complied with. So if you have a party trying to restrict you with strict time bars, what defenses are available to you? The first is called conventional estoppel. This is an argument to say that the parties had a common assumption during the course of their relationship that the time bar clauses would not be enforced, and the parties conducted themselves on that basis. So that was their convention. Secondly, there's the idea of waiver. That is, one party waived the requirement for the other party to comply with the time bar provisions, either verbally or in writing. Third, the variation of contract argument. The contract was varied by an agreement, either verbal or in writing, with the effect that the time bar provisions were deleted from the contract. And finally, Section 34 of the Building and Construction Industry Security of Payment Act, an argument to the effect that the time bar clauses were so impossible to comply with that they restricted, modified, or excluded a party's entitlement to claim for work carried out under the Act. So again, the defense available to a contractor would depend on their particular circumstances. So some more key takeaways for you from the CMA Assets and John Holland case. There is a critical need to comply with time-related provisions of a contract, including for extension of time delays, extension of time claims and variation claims. Yes, this is a significant administrative burden on contractors. Often contractors are too busy with the work on the ground that they forget about the work that needs to be done in the office as well. The risk of that non-compliance is catastrophic, really, including being denied extension of time, being denied claims for delay costs, variation claims, and having to pay liquidated damages due to delays. Keep detailed records. Can't stress that one enough. All the information you need for your notices should be available really easily. Maintain daily records regarding work progress and any issues that you encounter. And finally, the courts will uphold strict time bar clauses, even if they are unfair or harsh, which can cost you a lot of money. Finally, just a short note on dispute resolution clauses. So this graph shows the different types of dispute resolution. The y-axis shows the increasing cost and hostility involved as you go up, and the x-axis shows the decreasing level of control that the parties have on the outcome, moving to the right. So you can stipulate any one or more of these methods to resolve disputes in your contract. So moving from left to right, I'll just outline some of the common methods of dispute resolution. The first one, the obvious one, negotiation. So the parties meet to negotiate. Usually in a contract, you'll say that it has to happen within a certain period of time after issuing a notice of delay. The second one, more common one, is mediation. The parties attend a meeting, which is a negotiation, but chaired by a mediator who conducts and controls the mediation. You have an arbitration towards the right there, where an arbitrator is appointed and makes a decision which is binding, but gives the parties less control of the outcome. And finally, you have litigation, which is the most costly and most hostile and gives you the least amount of control of your outcome. There is wide scope to construct your own process into your construction contracts that incorporates one or more of these methods. So you should always seek advice on your options. Also important to consider what's most effective for you, for the other contracting party, and what will provide the most quick, cost-effective and fair determination of your disagreements, and get advice in relation to the wording of your contracts. So that sums it up. Thank you all very much. As I said earlier, please feel free to follow Kreisson on all our social media platforms. And our latest publication is a new ebook on major changes to the New South Wales building industry, a handbook for residential design and building practitioners. I invite you to have a look at that one too. So thank you all very much. Happy to take any questions if we have time.
Thank you, Anish, for a very interesting presentation. Do we have any questions out there, please? In the interim, the real couple of takeaways from me was just in the quantum Meruit and understanding that. I think a lot of us know of the as layman lawyers, and no disrespect to you intended, but to understand that principle, we know it, but we don't have any idea of its application. And it was really good to be able to see that. So thank you for that, Anish. And then the other one, just that very simple graph of the dispute resolution process, and just showing that loss of control that you that you encompass as you move up the scale of the litigation or the process of trying to resolve the problem. Right. Thank you. Are there any further questions out there?
Yeah, Joel from Harder in General has asked, do extension of time clauses apply to material suppliers?
That's a very good question. It would depend on the contract. If there are any delays in supplies, it certainly may be claimable. But again, it depends on the contract and what's permissible in the contract. So the counter argument may be, well, what are the things that you should have reasonably foreseen and things like of that nature. But certainly would be worth considering putting in a notice, that you anticipate this likely delay and following the contract procedure.
Okay, thank you. Thank you, Anish. I guess yeah. Again, our many thanks for such an interesting and a great presentation.